Obligation of a person enjoying benefit of a non-gratuitous act. Where a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and such other person enjoys the benefit thereof, the latter is bound to make compensation to the former in respect of or to restore the thing so done or delivered. Illustration. A tradesman leaves his goods at B's place or home by mistake. B treats the goods as his own. He is bound to pay for them. A saves B's property from fire. A is not entitled to compensation from B if the circumstances show that he intended to act gratuitously. Conditions for liability under the section. According to Justice Gajendra Gadkekar in State of West Bengal versus B.K. Mondal and Sons, the conditions on which the liability under this section arises would be: A. A person should lawfully do something for another person or deliver something to him. B. In doing the said thing or delivering the said thing, he must not intend to act gratuitously. And C. The other person for whom something is done or to whom something is delivered must enjoy the benefit thereof. Number 1. Not intending to do so gratuitously. Thus, one of the purposes of this section is to assure payment to a person who has done something for another voluntarily, yet with the thought of being paid. He should have contemplated being paid from the very beginning. In Municipal Council Rajgarh versus Madhya Pradesh State Road Transport Corporation, the Municipal Council, which had constructed and maintained a bus stand, was allowed to recover some charges from bus operators who used the stand, though there was no agreement to that effect. Number 2. Section does not encourage officious interference in affairs of another. Secondly, the person for whom the act is done is not bound to pay unless he had the choice to reject the services. If a person delivers something to another, it would be open to the latter to refuse to accept the thing and return it. In that case, Section 70 would not come into operation. In other words, the person said to be liable under Section 70 always has the option not to accept the thing. It is only where he voluntarily accepts the thing or enjoys the work done that the liability under Section 70 arises. In the application of this principle, the courts have had to strike a balance between two factors. Firstly, the rule cannot be used by anybody to make officious interference in the affairs of another. Number 2. Secondly, the courts will not compel a person to pay for the services which have been thrust upon him against his will. Number 3. Request for service creates implied promise to pay. Yet, the third necessity is that the services should have been rendered without any request. Reasonable compensation may, however, be recovered for the services rendered at request. This has been held so by the Supreme Court in State of West Bengal versus B.K. Mondal and Sons. The facts of the case are: the plaintiff, on the request of an officer of the State of West Bengal, constructed a kacha road, guard room, office, etc. for the use of the Civil Supplies Department of the government. The state accepted the work but tried to escape the liability under the pretense that no contract had been concluded, in accordance with the requirements of Section 175, Clause 3 of the Government of India Act 1935, now Article 299 of the Constitution of India. The contractor finally was forced to use his luck with the state under Section 70 of the Contract Act 1872. And finally, the Supreme Court held that the state is liable to reimburse the contractor. The principle of this case has been reaffirmed by the Supreme Court in Pillow Dunji Shah Siddha versus Municipal Corporation of the City of Pune. Number 4. Lawfully does. Fourthly, services should have been rendered lawfully. It has been a point of emphasis that between the person claiming compensation and the person from whom it is claimed, some lawful relationship must exist, and it should arise by reason of the fact that what has been done for the former has been accepted and enjoyed by the latter. Number 5. Non-gratuitous acts. In the fifth place, the person rendering service should not have intended to act gratuitously. The decision of the Madras High Court in Dharmodara Mudaliyar versus Secretary of State for India is the leading authority. In this case, a number of villages were drawing irrigation waters from the tank. Some of the villages were under the direct state tenancy, the others under the zamindar. The government carried out repairs to the tank for its preservation. The zamindar also enjoyed the benefit of the repairs. It was accordingly held that the zamindar is liable to make proportional contribution towards the expense of the repairs. Number 6. Enjoys the benefit. Lastly, the defendant must have enjoyed or derived a direct benefit from the payment or services, as for where no services have been rendered at all, for example, where the government cancelled the lease granted to the plaintiff by an officer who was not so authorized, no relief can be allowed under this section. In Prashant Raj versus Arunab Kumar and others, the plaintiff worked for the defendant's proprietary concern. The defendants accepted the work done by the plaintiff. The work done by the plaintiff benefited the defendant's proprietary concern. The court held that the plaintiff was entitled to compensation for work done by him under Section 70 of the Contract Act. Where it is shown that some work has been done and the same has been accepted, then the party, that is the acceptor, cannot turn around and say that the payment cannot be made on the ground of lack of his competence to accept the work. That would amount to unjust enrichment and is contrary to the provisions of Section 70.